Bismillahirrahmanirrahim. Sources of international law. As we explained in previous lecture, treaties as source of international law. This lecture is also in continuity of previous one. The third important source of international law is decisions of judicial or arbitral tribunals. It further be classified or divided into international judicial decisions, state judicial decisions, and decisions of international arbitral tribunals. No? The first one, international judicial decisions. The existing permanent international judicial tribunal is the International Court of Justice. It has general jurisdiction and succeeded the former Permanent Court of International Justice in 1946, which itself was created in 1921. It is misleading fact that the decisions of international court is a binding and direct source of international law, but actually it is not a binding on parties other than party to the case before the ICJ, and it is also binding on the parties to the case only, and not to the other parties. But it still has provided a good share in formation of international law in its development, because it provides rules for guidance and rules for international law regarding cases before International Court of Justice ICJ. The second one is the state judicial decisions. State judicial decisions also has contributed in formation of international law. The decisions of the courts may be treated as weighty precedents as binding authorities. In Benston Boyle case, Justice Marshall of United States observed the decisions of the courts of every country, how the law of nation in the given case is understood in that country and will be considered in adopting the rule which is to prevail in this case. The other famous example is also the Great Britain Prize Court Judge Lord Stowell in 1745 to 1836, who presided over the court during the Napoleonic Wars. His judgment received a universal acknowledgement as an authoritative declaration of the law. He held that blockade to the binding must be effective, that contraband of war is to be determined by probable destination and doctrine of continuous voyages. The second one is also the decisions of the state courts may also under the same principle as dictate the formation of custom led directly to the growth of customary rules of international law. The certain rules of extradition law and state recognition were in the first instance derived from the uniform decisions of the state courts. The third one is decisions of international arbitral tribunals. Regarding arbitration under state law or the law of land, the arbitration before international tribunals or international permanent arbitral tribunals, also binding party to the arbitration or party to before the arbitrators. The famous tribunals such as Permanent Court of Arbitration, the Britain American Mixed Claims Tribunal, and other laws, Alabama Claims Arbitration 1872, etc. Some writers have not recognized this contribution on the basis of alleged fundamental distinction between the arbitral and judicial decisions. They were of the view that the arbitrators have, as a general practice, tended to act as negotiators or diplomatic agents rather than as judges on questions of fact and law. This is the valid criticism which the critic had put on the decisions of international arbitral tribunals regarding source of international law. The fourth source of international law is jurist works. It is also not a binding source and not a direct source, but it also in the list of paragraph 1 of Article 38 of Statutes of International Court of Justice as a source of international law. It has also played a great role in development of international law. The works of the jurist are not an independent source of international law, although their opinions do the lead to the formation of law. The opinions of jurists throw light on the rules of international law and rendering their formation easier. In Pakit Habana case 19, it was observed by Justice Gray of the United States Supreme Court. He was of the view where there is no treaty and no controlling executive or legislative act or judicial decision, resort must be had to be customs and usage of civilized nations, and as a evidence of these, to the works of the jurists and commentators who by years of labor, research and experience have made themselves especially well acquainted with the subjects of which they treat. Uh, Therefore, it is proven fact and it is a precedent and recognized by statutes of International Court of Justice that works of the jurists and statesmen of international law had also a source of international law and played a great role in development and formation of international law and rules regarding regulating the conflicts before the courts, where there no other source of international law or no other rule is available. Thank you very much.